Harvard, its motto is Veritas, and it truly just won a major decision against the Trump administration at the hands of Judge Burroughs in Massachusetts. It's a victory not just for Harvard, but for all of liberal education and higher education in their fight against Donald Trump. You want to know more about the $2.2 billion in research grants? What is it about this administration and going after and undermining public health? The research grants are being used by Harvard not to promote anti-Semitism, which is some sort of crazy argument that Trump was trying to make, but it's being used for medical and scientific breakthroughs that help us. That's where the research gets done, in research universities. And now that money's been reinstated. We talk about it on the Legal AF podcast, and here's a clip. Kara, let's kick it off with Harvard and what happened there. So Judge Burroughs, who's been on this case as a federal judge of Massachusetts for like 5 months now, we've already gone through and covered all of her temporary restraining orders, preliminary injunctions, and now we're going to talk about her summary judgment, which means game, set, match against the Trump administration for cutting $2.2 billion worth of research grants. I want to make sure everybody understands these are research grants to help the American people because Donald Trump, under as the judge called it, a smokescreen of combating anti-Semitism, decided they wanted to do a hostile takeover of Harvard, tell them who they can hire, who they can tenure, what they can teach, who they can admit in. And Harvard said, go legal AF yourself. I mean, in their own Harvard style. A lot of Veritas, which is their motto, a lot of truth and stand up and fight, and led by a very courageous president and Alan Garber. And finally, after winning every round, it came time for the summary judgments. Trump administration filed summary judgment saying they should win. The Harvard said we should win on their case was premised on our First Amendment rights have been violated. Who we can hire, who we can fire, what we can teach. They're being violated in retaliatory fashion and vindictive fashion by the Trump administration under the guise of anti-Semitism. What they really don't like is our commitment to diversity, equity, and inclusion. They don't like what we teach. And they're claiming it's because we have a poor record of trying to handle anti-Semitism on campus, a lot of which happened after Hamas attacked Israel. And the judge took a look at all of this, Karen, right? And came up with her own conclusions in reinstating the grants. Why don't you take it from there?
Look, she basically, well, she could have just ruled against the government and ruled in favor of Harvard, but she went on this very, very long description about why she was ruling what she was ruling in her decision. And I thought it was really powerful. She said, we have to fight against anti-Semitism and protect our rights, including the right of free speech. And neither goal should be sacrificed on the altar of the other. And so she basically said, look, the court's job is to step up and safeguard academic freedom and freedom of speech and ensure that important research is not improperly subjected to arbitrary and procedurally infirm grant terminations or risk the wrath of the government, no matter the cost. I mean, pretty powerful language in there. My favorite part of the decision was one of the footnotes. I always love footnotes. That's where you kind of get some really powerful language sometimes. She basically said, look, the court is mindful of the Supreme Court in certain other agreements that basically, in certain other decisions, that basically says, look, the court is not free to defy the Supreme Court decisions, and we're duty bound to respect the hierarchy of the federal court system. Okay. And she acknowledges that. But she says, consistent with these obligations, this court, like all district courts, are trying to follow the Supreme Court's ruling, no matter how misguided it may think that it is. And she said, the Supreme Court's recent emergency docket rulings regarding grant terminations have not been models of clarity and have left many issues unresolved. She's sort of calling out this shadow docket, right? Because when you go on these emergency shadow docket rulings that the Trump presidency basically it's what's enabling the Trump presidency to do all these things that they're doing. What happens is they don't fully brief the issues. There's no oral argument. There's no presentation of both sides. And then there's no sort of decision, right? There's no merits decision by the Supreme Court. Instead, they're getting these couple of paragraph rulings from the Supreme Court on issues that aren't fully briefed. And the problem with that, what she's saying is you're not giving any guidance to the district courts. And so we're trying to interpret this mess, this soupy mess that you're creating, Supreme Court, by making all these shadow docket rulings that are really not based in doctrinal law or precedent. So she kind of goes on to say, that, she talks about some of the recent grant decisions and grant termination cases and trying to make sense of them. But she says, given this, the court respectfully submits that it is unhelpful and unnecessary to criticize district courts for, quote, defying the Supreme Court when they are working to find the right answer in a rapidly evolving doctrinal landscape where they must grapple with both existing precedent and interim guidance from the Supreme Court that appears to set that precedent aside without much explanation or consensus. That was a direct message to the Supreme Court, basically saying, you're not being helpful here. You got to give us some guidance because you're basically lawless. And so we're trying to follow the law and follow what you say, but you're not really spelling it out. So I thought it was a really powerful decision.
Oh, absolutely. I'll just read one. And consistent with that, I'll read one thing that she says in her conclusion on page 79, where she just spent 20 pages using Donald Trump's own words against him. Like, in other words, I'll give the summary. Don't tell me this is about anti-Semitism. There's anti-Semitism that needs to be better handled on campus. I agree. There's research grants that have zero to do with combating anti-Semitism. It's not like they're doing research on, it's not like, during the Holocaust when they were doing research on Jews and we needed to cut the funding because it's anti-Semitic in the style of their research. There's no link between the two things. What you're really doing is you're taking away their money to penalize a higher education institution because you don't like their viewpoint. You don't like their First Amendment views. And that's exactly what you cannot do. And she pointed to all the places where for about 10 weeks straight, Donald Trump didn't talk about, in his bashing of Harvard, which became the evidence in the case, didn't talk about on his social media, I'm taking the money away in order to fight anti-Semitism. He said it's about their left woke, bird brain faculty teaching students to fail. It was all about their viewpoint, what they're teaching, their curricula, not about the research grant. So he screwed himself providing evidence of the discrimination, the First Amendment discrimination in his own social media post. But this is now like the 12th judge who's been able to use, or more, that's been able to use Donald Trump's own words against him as evidence. Here's what she says to end the decision. After she goes through the fact that there is anti-Semitism on campus. That said, there is in reality little connection between the research affected by the grant terminations and anti-Semitism. In fact, a review of the administrative record makes it difficult to conclude anything other than defendants used anti-Semitism as a smokescreen for a targeted, ideologically motivated assault on this country's premier universities. Because it's not just Harvard. It's Duke, it's Columbia, it's Princeton, it's UCLA, it's Berkeley. He's gone after there's a guy, I'm going to do a hot take on him one day. There's a guy within the administration that is their guy to go after, quote unquote, these woke universities. He's almost like the Laura Loomer of the education police for Donald Trump. And they're just following his list. So she knows it's not just about Harvard. But she said, but to do so in a way is a smokescreen for targeted, ideologically motivated assault on the universities in a way that runs afoul of the Administrative Procedures Act, the First Amendment, and Title VI. Further, their actions have jeopardized decades of research. Think about that. They were in the middle of research. that had to be ended because the grants were taken away, and the welfare of all those who could stand to benefit from that research, as well as reflect a disregard for the rights protected by the Constitution. And what is it with this administration? It's the worst administration I've ever seen in history against public health. Welcome back, Legal AF, the podcast. It's top 15 in the world. That's because of you. Help us continue to grow that podcast, the full-length version, Wednesday and Saturdays at 8 p.m. Eastern Time on the Midas Touch Network. And then wherever you pick up your audio podcast from, you'll find Legal AF. You're already on Legal AF YouTube. Hit the free subscribe button. Help us continue to grow this channel. We're going to hit 1 million before the new year, for sure, with your help. It's all for free, no outside investors. And then if you come over to Legal AF Substack, I think you're going to find an amazing community there. It's over 800, it's almost 800,000 people already and growing. I do 2 live reports every day where I bring together 3,000 people on a moment's notice to give them an update in something at the intersection of law and politics. While you're here, hit the free subscribe button for Legal AF as well. Until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.